On behalf of the CAM Santiago team, I'm warmly welcome to you the signing ceremony of the Memorandum of Understanding between the Singapore International Arbitration Center and our institution. We are really pleased to announce this collaborative alliance that allows us to promote international arbitrations as a preference method to resolving international dispute resolutions and to enhance the accessibility, efficiency, and effectiveness of international arbitration. After the signing ceremony, we will have a conversation about the future of the role of arbitral institutions in the evolution of arbitration. We hope you enjoyed today's conversation and that we can meet soon in Santiago, right? So without further ado, I give the floor to Macarena Letelier, Executive Director of CAM Santiago. Macarena.
Thank you, Laura. Well, first of all, just to say hello to everyone, especially here to Lim Seok Hui and Kevin Nash, who are joining us on this ceremony, first to sign our agreement and then to have a small conversation between these institutions. As Laura told you, today we are signing a memorandum of understanding between the Singapore International Arbitration Center and the Santiago Arbitration and Mediation Center. As you all know, SIAC is a leading international arbitration institution with a track record for providing quality, defiance, and neutral arbitration service. And CAM Santiago is a nonprofit institution that is established in 1992 by the Santiago Chamber of Commerce, which offers the service of national and international arbitration, mediation, dispute board for resolution of disputes. Today, in what we are living in this globalized world, I think is a very good news for everyone to know this networking between our centers. And now we're going to proceed to sign this agreement just maybe for the pictures as we were talking, because then we will exchange the documents between the institutions. And then I will give the floor to Lim and then start a conversation between both institutions. So if you're okay with us, we are going to take a picture just as signing this MOU for the record, as we say. So here is the pen. Thank you very much for trusting in us, Kevin and Lin Seok Hui, who are represented today as SIAC. Please, the floor is yours. You are on mute. You have to unmute.
Yes, that's right. Thanks, Macarena, and good evening from Singapore. I'm delighted to have signed this MOU on behalf of SIAC with our friends at CAM Santiago. Latin American market is extremely important to SIAC. In recent years, we've seen the number of Latin American parties grow steadily at our institution. And with the increasing trade and investment activity between Latin America and Asia, and the increasing popularity of international arbitration as the preferred method to resolve cross-border disputes, as confirmed in the 2021 Queen Mary survey released just a couple of months ago, this trend looks set to continue. With the launch of our Americas office last year, we intend to do much more in Latin America to promote international arbitration and to develop arbitration expertise in the region. Through this MOU, we look forward to deepening our engagement and to working closely with CAM Santiago to organize events and training programs on arbitration that are tailored to the needs of the local community. Thank you.
Thank you very much for your words. And I'll ask Laura or Claudio if you can make a small introduction of who is joining us today to Kevin Nash.
Of course, we're really happy to sign this MOU with you and have you today. So for this conversation, we have Kevin Nash, Deputy Registrar and Center Director. As Deputy Registrar and Center Director, Kevin assists the Register in the administration of all the cases filed with SIAC and supervision of SIAC and Multinational Secretariat. Kevin holds a BA from Mount Allison University and a JD from Osgoode Hall Law School. Kevin worked at one of Canada's prominent Seven Sisters law firm, and then went to the study an LLM in International Commercial Arbitration at Stockholm University. He is qualified as a barrister and solicitor with the Law Society of Upper Canada. And we are really glad to have you today, Kevin. We know Adriana Usen, she's the head of Americas from SIAC, and she couldn't be able to be here today, but we are really glad to have you on this conversation with Macarena. So we can start. Claudia, you have the questions to start with the conversation, please.
Thank you, Laura, and thank you, Kevin. On the other hand, we have Mrs. Macarena Letelier. Macarena is a lawyer and she's master in public law from the University of Chile. She also has a diploma in economic public law from the University of Chile and studies on Harvard negotiation. Macarena is also the vice president of the Inter-American Commercial Arbitration Commission, co-secretary general of the Arbitration and ADF Commission of ICC Chile, a member of the Civil Procedure Reform Commission of the Ministry of Justice and Human Rights of the Republic of Chile. So to start this conversation, I would like to ask both Macarena and Kevin, what do you think that are the most important facts that you will highlight since the foundation of the Singapore International Arbitration Center and Camp Santiago?
Thank you, Claudio. And Kevin, if you let me say some few words before I give you the floor, just to maybe tell today that one of the most highlights I see here is knowing about the best standards of the administrations and that the centers make with their teams and their rules, and almost with the technology that we are using today during this pandemic situation, but not just because of what we are living today, because it's part of the present and the future, to introduce technology in the administration of justice, to make it closer for people, an easy way to resolve the conflicts. And I think that there will have a very good issue to talk and to develop together, and many other things. Just to tell you that we have created like an institution inside Camp Santiago of very young arbitrators too. And they are lawyers that have studied in other countries, that they manage different language. So I think they are going to be the most happiest people today with this MOU, because they are part of the future in giving justice to the people that wants to begin like walking through an arbitration or mediation system, to have dignity, peace, and to we always talk that in this economic crisis because of the pandemic, it's a very good news that arbitration and mediation in short times give you the results of the conflicts, because then you can go over developing the economy for have a very a better life for all the people in the world. So Kevin, please.
Macarena, I certainly second everything that you've said. And ultimately, that's what we're doing as arbitration institutions. We are trying to resolve disputes. Arbitration is the grease on the wheels of international commerce, and it's never been more important during COVID-19. One thing that I think is very important about how institutions work together during COVID-19, and this MOU is emblematic of the fact that institutions want to exchange ideas and develop best practices. Laura, I should say to you that I am standing in for Adriana Usan, who's our head Americas. Claudio, when you asked about the 5 facts, I would say the establishment of SIAC Americas is one of the biggest facts. And when you look at our 2 institutions, 29 years old and 30 years old, SIAC Americas is our 5th overseas office, and it really shows how SIAC has expanded its global reach. So we started as a regional institution with just 2 cases in our first year. We had more than 1,000 cases last year, which included 2 packs of consolidated cases. And Macarena, I'm sure you all see this at CAM Santiago, is how do you maintain the service standards when you get bigger and bigger? Because institutions are often talking about their statistics, and statistics are important. The reason why statistics matter is because if you're a user, you want to see an institution and you say, wow, they've administered a lot of cases, so they're not going to come up with a new situation on my case. That's the only reason statistics matter. It shows the penetration of arbitration clauses in the market and that you have experience under your rules. But how do you maintain that gold class service at 2 cases and 1,080 cases? When I started at SIAC, and I almost want to lie about how long ago it was, we had 4 or 5 lawyers. Now we have a disputes resolution team of 16 lawyers, international lawyers in the Secretariat. Our business development department under Lim Suk Wee, these are all experienced disputes lawyers. Adriana was with me in the Secretariat. We administered hundreds of cases. She went back to practice, sits as an arbitrator, investment arbitration, commercial arbitration. So SIAC is a really big machine. But what I think that we've done and remained faithful to is the idea that we are there to resolve disputes. The institution is there to make sure that the core tenets of arbitration are being adhered to. And we all know why we choose arbitration. It is fast, it's cost effective, it's flexible, limited avenues of appeal, enforceable, choose your decider, all of these things, that's what we're doing as an institution. So if we can resolve these disputes very quickly, particularly during COVID-19 with elements that we have at SIAC, such as the expedited procedure, early dismissal, emergency arbitration, and that can get parties to a resolution, that is exactly what we're there for. That's what CAM Santiago is there for. And it's also for users from all around the world to have different institutional options. So on one transaction, you could have an Asian party and a Chilean party, and they want to use CAM Santiago. For that deal, CAM Santiago makes sense. In the next case, it could be SIAC rules with a Santiago seat or a Singapore seat or Miami or New York. And this is what's really good about arbitration right now, the preferred method of cross-border disputes, and there's more and more options. And when we look at the map and you think about the challenges that we've faced during COVID-19, the world is so small now. Chilean parties can choose to have an SIAC arbitration with a Singapore seat. We want them to travel to Singapore and get to experience the effect of Maxwell Chambers, but they don't have to. We've got Adriana, who's operating on Eastern Standard Time. We've got presidents and vice presidents and court members all over the globe. So what I think is that users are spoiled for choice. And the good thing about these MOUs and institutions working together is that we're even going to get better. So for us, what we're looking at is what do Latin American parties need in particular? So we've had lots of disputes with Latin American parties, but are they using more tiered clauses? Is speed paramount? And then the same way, hopefully in our direction with you, is that we can help or enhance and inform you on the preferences of parties in Asia Pacific. So Macarena, Laura, we are delighted to be a part of this MOU and a part of this conversation right now and hopefully going forward.
Thank you, Kevin, very much. You were talking about the teams. I think that is the most important part of the institution, the team that is behind the institution. And the Santiago Arbitration and Mediation Center Secretary team is led by the Executive Director and is comprised by a legal director. We have an international study office that is led by Laura Aguilera and with Claudio that I want to thank you them because they made possible this today too. And you know that our professionals are qualified individuals that receive constant training. And I think that the training is a very good point to talk and to work between the institutions, because we have a lot of collaboration with universities from Chile and from other countries. 2 years ago, we made a course with Boston College University at Boston, and we went there like 35 professionals. And I think that this is a very important thing, to be training always and to know what is happening in other countries, in other centers, with best practice, with transparency, for example. So the other thing that I want to tell you is that there are a lot of meetings of international initiatives that the centers are talking to. For example, in UNCITRAL in the United Nations, working with the accelerate procedures, or maybe knowing about the mediation convention, the mediation Singapore conventions. Yesterday, we had a meeting with our Ministry of Justice, and we asked as institution to ratify this agreement, this Singapore Convention mediation, because it's so important for our country. And we told the ministry of our conversation today, because it's part of what our authorities have to know that we work on, because this is not just for a group of people, it's for all the members of our country. So it's so important what we made together. Claudio, I don't know if you have another question that we have Kevin here.
Thank you, Macarena, and thank you, Kevin. My next question is to Kevin. As Mrs. Lim Seok Hui told us a few moments ago, according to the 2021 International Arbitration Survey, adapting arbitration to a changing world, Singapore is one of the 5 most preferred seats of arbitration, and the Singapore International Arbitration Center is one of the 5 most preferred arbitral institutions. What is the path that Singapore has followed to achieve these results?
Thank you, Claudio. When I look at Singapore, I look at the entire dispute resolution regime, and international arbitration is one piece of that. What we've really tried to do in Singapore is be able to resolve any kind of dispute on Singapore's shores. And we'll see from the latest Queen Mary survey as well, is that these tiered dispute resolutions are becoming more and more popular. Macarena, as you said, and that's very exciting news about the Singapore Convention, particularly in Asia Pacific, where there's a culture of conciliation. There will be a lot of relationships where mediation makes the most sense, or mediation and then arbitration. So MED-ARB, or from an SIAC standpoint, ARB-MED-ARB. We have a relationship with the Singapore International Mediation Center. So we look at international arbitration in Singapore. SIAC is one of 6 administering institutions. So you also have ICC, ICDR, Permanent Court of Arbitration, WIPO, Singapore Chamber of Maritime Arbitration. They are all administering cases out of Singapore. Then you have international mediation with the Singapore International Mediation Center for international mediation, and then the Singapore Mediation Center for domestic mediation. And then we have our Singapore International Commercial Court for international litigation. So that's what we're trying to do. We're trying to resolve disputes. Now, if parties happen to choose international arbitration, which they often do, Singapore is now tied with London as the most preferred seat in the world. And there's a lot of reasons for that, because Singapore has quite intentionally developed the legislation. The judiciary is very pro-arbitration. So there is an unequivocal judicial philosophy of the facilitation and promotion of arbitration. And you look at other language, that the rule of law is applied without fear or favor. And if you try to simplify it, the reason why parties from all around the world choose Singapore is they know they're going to get a fair resolution of their dispute. If you're a Latin American party and you are up against a big Singapore entity, you will still get a fair resolution of your dispute. And that's ultimately the litmus test when you're choosing a seat. What is the court's attitude to arbitration? Is it independent and neutral? Sometimes I look at Singapore and I think that everything just works in Singapore. You've got best in class legislation. You've got the very pro-Singapore High Court. If you want an international bench of jurists, you have the Singapore International Commercial Court. You have experts, domestic law firms, international law firms. It all just works in Singapore. So we are very privilege to be operating out of Singapore, but of course, arbitration is so flexible that the seat of arbitration for an SIAC arbitration can be in Santiago, it can be anywhere, or the seat can be Singapore. You take advantage of some of these features and then have the venue, assuming we go back to physical hearings, then have the venue in Santiago. So it's a really big part of what we do, the fact that we're in Singapore, and it's the success of SIAC and Singapore as a seat have kind of went hand in hand.
Thank you, Kevin. And Macarena, how is the relationship of Camp Santiago and the Chilean judiciary?
Well, I think that every day is more important, the relation between the judiciary and the arbitration in general, and then in a specific with institutions, because our case, Kevin, we have a very, very fluid relationship of collaboration, and we are interconnected. I don't know how to say it, that in our softwares are interconnected since we've signed an agreement like 4 years ago. And today that is like a reality. And it's a very good news because we have resources that have to be seen by the courts. So it's an easier way, it's a fast way. And living this year, the COVID, it was a different way to go on with our files because before we have to take them in a physical way. Today, we are interconnected. So that is, I think, I don't know if in another country this has been developed, but we feel a lot of responsibility because of the trust that the judiciary has shown to the arbitration systems, and especially who is administrated by Camp Santiago. Last year, we make a book with the past 18 years of the awards of the judiciary between arbitrations. And the president of the Supreme Court was the one that made the principal words that day. So I think we have begun a very, very good made of working with them. And we always want to show this to another country or institutions. And that is by the hand of the technology, because we have software that supports all our files in an electronic way. And it has been very, very useful this year too, because there's like a non-stop administration of the arbitrations in Camp Santiago. And we have to make it better every day because technology is always developing with better things and issues. So who leads that is Laura too. Maybe Laura, you can tell a few words, Kevin, about our platform that supports our files, more than 5,000 files of this year.
Yes, of course. We start working with this platform in 2013. So in Chile, we were the first and the only one, I think, in the private sector that administered cases about this in this platform. So in this time, we know that all the technology all the time is a continued evolution. So we're right now going forward in this and making all the progress that we need, and we know the users right now need. And of course, this opened the doors for us to the world too, because all the arbitrators and mediators that work in the platform can do it wherever they be. So for us, it's a really good asset to the center, right? So administrate the cases in the platforms that everyone can join and check all the files, the documents. So you have transparency to the parties and also efficiency. You can reduce costs in this because you'll have less paper, right, and everything. And you can reduce also the traveling around the world, because with we have this time of the pandemic, right? The platform give us the floor to reaction really quick to this, right? So continue with all the services, and more than the 80% of our cases continue with the proceedings. We didn't stop. So that for us, well, that was a really good news for all the users of arbitrations and give solid words, solid grounds to the arbitrations too. Right now, we're working in another evolution that is online dispute resolution that have a new line to B2B and B2C, and we are working with the chambers of commerce on that in B2C to give a quick resolution on the platform to consumer cases, right? So for us, it's a really good evolution. We go forward with the technology, and we know that this is going to be the future for everyone. Of course, this is a tool for the arbitrators and the lawyers that participate. We don't think that this replace the human work, right? But it's a tool that we can use to give and provide better access to the justice.
Laura, because we're calling this a conversation, could I ask a question for your online document management? So every case at Santiago, do you automatically have your documents are hosted electronically, or do parties still file physical copies?
Yeah, that's right. Everything is in the platform. The people upload the clients and documents there. So the whole proceeding, you have it on the platform. So for us, it's really good because all we have, of course, like you said, you have a team, right, before the administration of the cases, and they also work on the platform, supporting and give the feedback to the parties, to the lawyers, and to the arbitrator in the works of the arbitrators. So for us, this is a really good asset to the center. So like you said, everything is in the platform. Of course, sometimes if you have some difficulty with some documents, you can have in another form of format, digital format, right? But everything is right now doing by this platform.
Okay. Maybe Kevin, just to complete what Laura said, we are not receiving physical documents like 2 years ago, I think, since 2 years. But the point that makes us to say no more physical documents was this agreement with the judiciary, because before we have the platform for CAM Santiago, we have the file in the software, but when the file has to go to the judiciary, we have to have it physical. But today we don't need that. So as Laura told you, we will always support the parties. As if you have a big document that you can make it digital, well, we are going to look the best way to protect your defense. But we don't have any physical documents today.
That's great. I mean,
how is this managed? How do you do this in Singapore Center?
It's both, but I mean, I think the philosophy is similar. The way that we look at it is the disputes we are getting are enormously complex. So it might be a $5 billion USD dispute. You want to make the procedure for filing and all of your interaction with the institution easy, because the dispute's already complex. So we've certainly been trying to move parties to electronic communication. There are some challenges in terms of, say, physical delivery of awards. Is a wet ink signature required in a certain jurisdiction? Because we perform the scrutiny of awards, we're looking at and trying to protect and enhance the enforceability of the awards. So what we'll do is we'll transmit electronic copies, but also the physical copy with the wet ink signature. Prudent tribunals will tend to try to get the parties to agree to electronic transmission, particularly during the most difficult parts of the pandemic. And for us, we were very fortunate to have a case management system, because to me, the interesting part about COVID-19 is that for a few days, the entire world of dispute resolution looked to all the institutions and we're kind of asking, what do we do now? And nothing stopped except for those first 2 days, because most of us had already developed case management systems, CAM Santiago, with your document management. So we were already able to operate remotely, thankfully. So then we had people, we had our secretariat on split teams, working from home, sometimes going into the office. And so the disputes were being resolved just as fast, or if not faster, than they were when we were physically in the office. And it was a similar situation for remote hearings that I imagine that you all have had this experience, is that previously you would have expert witnesses and fact witnesses participating remotely. That was quite normal in arbitration. The difference that we had during COVID-19 and we have now is that the entire arbitration is remote. And Singapore is a bit unique because of the way the COVID-19 crisis has been handled, is that there still have been physical hearings. So we effectively have 3 different types of hearings. You might have a fully physical hearing if you have both sets of counsel, tribunal members in Singapore, a hybrid hearing where, say, the presiding arbitrators in person, both sets of counsels in person, and then the co-arbitrators participating remotely, and then situations where it's entirely remotely. So it's certainly the way of the future in terms of the system that CAM Santiago has. I think that the days of getting, say, 8 copies of the notice of arbitration in effectively a big wheelbarrow, all of those physical copies, because we want to be green in arbitration, but we also want to, at the same time, when we're looking at online solutions, we have to be cognizant of data protection, confidentiality. In addition to making it easy, you also want the users to have full confidence in the system. And sometimes arbitration, I think particularly, can be a bit reluctant to move from things that works, especially if you're dealing with, say, very senior arbitrators. So you have to show the arbitrators, the counsel, and the users why this is a better way to do it. That it's all the same as before, but just a bit quicker and a bit more efficient.
Yes.
Yeah, that's right.
That's a good point, because we work especially with our arbitrators that have more years, because maybe it's not easy. It's not easy for me to go on this technology. I always ask help to Laura, to my kids. So we have to empathize with this change of culture. But I think this is just what we have now, and we have to take the best things for the people and for the times in arbitration. And I think that maybe one of our first work together, it will be for us to show you our new ODR, Online Dispute Resolution. As Laura told you, Kevin, it has been a very well received platform for all the claims of customs, and in all of, for example, Cyber Days with e-commerce. And this year it has been increased a lot of the sales. And we learned about that in APEC. We were invited to a meeting, and then they were talking about ODR and like a guide to make it possible. And we began working on a pilot. And today we have just more than 100 companies over these systems. And the good news is that in 48 hours, you have resolved the claims between the person who buys something by e-commerce and the company. So we are working on that, and maybe we can make things together too in that program.
Yeah, no, and also if I can add something about we're talking about the video conferencing and how we go forward. In this case, CAM Santiago have the possibility, right, to have more than 2,000 audience hearings, sorry, about everything remotely, like video conference, witnesses, and everything. So the parties really and the lawyers adjust to the new situation, right? So for us, probably we think in the future this might be like an hybrid, like you said. Some people will prefer physical hearings, right, and others will be remain with the remotely. So for the future, I think all the technology is gonna stay, and we are gonna. Right now, we are working right now in improving our platform. CAM Santiago is gonna have changes because we know we need it, and we have to do the best for the users and the persons that use the technology with us.
Laura, one of this technology and remote hearings, Macarena, you had mentioned that you have a roster of young arbitrators.
Yeah.
To me, that's been one of the best things about remote hearings, is that it allows institutions to appoint the best arbitrators in the world wherever they are in the world. And I think that's one of the elements that's made SIAC very popular, is that we have Gary Bourne, the president of the SIAC court, making the appointment. And when you have Gary Bourne making these appointments,
we are Gary Bourne fans, Kevin.
yes, and we all are, and you're not limited by travel time and potential expense to the parties. It allows us to take a very nuanced approach to appointment, make our appointments more diverse. So I think there's lots of opportunities, and particularly with Adriana heading the Americas, for us to be able to engage with that next generation of arbitrators in Chile and Latin America.
Yeah, Macarena, maybe you wanna
Laura,
something about young arbitrators?
Well, young arbitrator was an idea that began 4 years ago, 5 years ago, because there were a lot of small cases coming to Santiago, Kevin, and then we thought maybe this can be like a different knowledge for the new arbitrators, but not just to make studies and courses and making some meetings between them, but also resolving cases. So we have like a small amount for them, that the ones that want to resolve these cases with arbitration. So it has been a very, very good experience. They all like governance, they own governance. They are like 40 professionals, they work together. When I see them, I don't feel like different lawyer office. I see a team of young arbitrators that wants to make more access the justice to people, and they're looking to another countries, institutions. As I told you, the most part of them has studied in other countries. They manage language, so it's easier for them to know about this in less time. And they a lot of them has worked with experienced arbitrators, so they have like they have been taught very well. So it has been a good experience, and the most important thing is that a lot of cases that before didn't came to arbitration system because of the prices, now they are coming to Santiago, and in 6 months is, I think, the average, Laura, that they have the award, or in 3-4 months they have like a agreement. So it has been, the statistics are very, very good, and it's increasing every time, and I'm very proud of our young arbitrator team.
Yeah, and also we can add, like, since the good results of the group and the working of the young arbitrators, that I can see some of them are connecting up and join us in this webinar, in this conversation. They have a expedited arbitration procedure, like you just said before, which has been agreed by the terms of referral of the parties, and it will be incorporated to the Camp Santiago. We have now new rules this year, so we add this expedited arbitration procedure because before we do this way, we propose to the parties and they have to agree to these rules. But right now is in the arbitration, domestic arbitration rules 2021, in order to formalize, right, the use and the tool available to the parties to resolve the conflict in an expeditious way. So that for us is a really good news, because we can we change our actually rules for the better administration of the cases.
Yeah, expedited procedure is a great place for young arbitrators to get experience, and we've actually had really good results with young arbitrators. This is partly due to our scrutiny process. because the first appointment can be daunting for an arbitrator. Even if you're very experienced as a counsel, that first appointment, and I think that's one of the advantages of institutional arbitration, is that you have the support of the institution. And what we see and what I've seen over my time at SIAC is that this first appointment for a young arbitrator, if this person does well, and because we're reviewing the award and doing the entire forensics on the case, that the next time a slightly higher value case that's a bit more complex, this person will be appointed. So you can see how an arbitrator career starts to develop. So at SIAC, we have a non-published reserve panel and a main public panel. And the main public panel, very eminent arbitrators, and we'd certainly encourage any Latin American arbitrators to apply to join the SIAC panel. But you will see people that start from this reserve panel and now are very well-established members of the main panel of arbitrators. So for me, and particularly with younger practitioners, it's very fun to watch these arbitration careers develop, especially for people that are very good. And I mean, I can think of offhand right now, we probably have of more than 1,000 active cases, almost all of them international. I would say that we probably have arbitrators between 29 years old and 89 years old.
Yeah.
That is the range of arbitrators, and across all different sectors and amounts in dispute. The only trick I find when we're recommending an appointment to the President Gary Bourne is that quantum does not always correlate with complexity. So you can have a very small dispute that is a bet the company dispute. The parties, it's very contentious, and you have to appoint someone very senior. It could be an English silk or a very senior member of the arbitration bar. And sometimes you can appoint a younger arbitrator. There could be a very high value dispute that just turns on a question of interpretation of a clause. That's all the dispute is about, but it might be $100 million dispute. So you can't always go by quantum, but you want to put those young arbitrators in a position where they will succeed, and it is the start of more appointments at the institution.
You have the reason, Kevin, and that's why since this year, the amount of the cases that are known by this young arbitrator, our council higher than up, because the very well work that they have made make them think about what you are saying. But by the other part, when the amounts of the arbitrations are more high or higher, you have very well known like lawyers behind the cases. So there is where you have to have more practice sometimes to management that hearings. So that is like a career that they are making. And since this year, when you have 40 years and you have been at least 3 years young arbitrator and you have no more than 5 cases, you can like pass immediately, automatically to the arbitrator list of Santiago, the seniors one. So that is a very good news for our young arbitrators too. And this year, 3 professional pass from young arbitrators for like the ordinary arbitrators. So you make a career in the institution too.
Of course, arbitration young is all relative. One of the great things about arbitration is you can have a 60-year or a 70-year career in arbitration, and you just keep getting better.
Oh, yes. Well, Claudio, you want to tell us something?
Yes, thank you, Magdalena. Thank you, Kevin, and thank you, Laura. Before we close this event, I have 2 more very quick questions. The first one to Mr. Natch is, how important do you think that ethical regulation is in alternative dispute resolution? And the second question is for the 3 of you, and it is, what role do you think that arbitral institutions should have in the academic training of the youngest generations?
If it's okay, I will start. And this is where I very much miss Adriana, who was supposed to speak tonight, because she's penned a couple articles on ethics in arbitration. But I think it's safe to say that institutions play a key role in both promoting and policing ethics. And one of the ways that you do that is by the confirmation of arbitrators and party-nominated arbitrators in particular. How an institution is running the disclosure process, particularly if you're looking at, say, the orange list on the IBA guidelines. So are you applying the same standard for a party nominated arbitrator, a joint nominee for sole arbitrator, co-arbitrator nomination for presiding arbitrator? What exactly is the nature of the disclosure? As an institution, are you going to have a philosophy where you're giving effect to party nominations and allowing this to route through the challenge process? Or are you going to be a bit more assertive where you're not going to confirm nominations? These are all questions that institutions have to answer. What I think that institutions want to encourage from all arbitrators is full and frank disclosure prior to accepting a case. The arbitrators need to be confident that institutions are going to do the right thing with the disclosures. Where a problem can arise is when a disclosure comes after the fact, after the arbitrator is accepted. Because if you think about it, when an arbitrator accepts a prospective appointment with disclosure, this person is already saying, I believe that I'm independent and impartial, but for good order, I make the following disclosures, and then you solicit comments from the parties. So we have the code of ethics. We're trying to be active. We want to be seen to be promoting ethics in arbitration, and we can do that in terms of how we're administering cases and the kind of thought leadership and scholarship that we're pushing out into the arbitration marketplace.
Yeah, that's true. It's really important. We also have a code for ethic code for the mediators, but in the case of the arbitrators, we have a committee of the board of the council that have this role with when something happens, good practice, and we also have some trainings when they get into the roster. So for us, it's really important that they have the experience of how we do in the center, right? How we administrate the cases. So in this training, we also discuss with them the conflict of interests that they can have. They have to reveal to the parties and to us if they have some issues to get the cases in arbitration. So for us, it's really important when we talk with them about the directions and where are the lines or the guidelines to be part of the Camp Santiago. I don't know if Macarena should want to add something else about that.
No, I think that the ethic rules are very important because they are part of the transparency that gives the institution with your website, with the amount of all the things in that people need to see before decide to go to an arbitration. We have like 3 that are of our councils that looks for maybe there are some claims about the rates of the timings, and the role of the institution is like being like a good bridge between the lawyers, the parties, and the judiciary, for example. And I think that the other part of the question of Claudio in the training is very important, the role of the institutions, because we see every day the cases, we see the practice. So in collaboration with universities, we can make a very good team there, not just to tell about the rules of the legislations, but we are making, I think, a very good thing with the Primut, Camp Santiago Primut, of Vienna, or of the competition that is organized by the University of Buenos Aires and Del Rosario in Colombia. And this has been a special year because Claudia and Laura leads there all these Primuts, and we have registered, I don't know, Claudio, like 30 universities from Europe, from every part of the world. And that makes us very happy because it's a way to recognize the work, Kevin, that we have been made with all our team, because we are just part of a big team and a big institution that has more than 100 years, that is the Chamber of Commerce of Santiago. So I don't know, Claudio, you have the numbers there of the last Vice Primut that we made this year.
Yes, we were able to reunite nearly, I don't know, 50 arbitrators from all over the world, and it was a very good experience for the teams of the Bismuth that are participating from Europe, Asia, and South America, of course.
Yeah, in the beginning, we do this really closely, like national domestic competition. promote, but then we open with the pandemic allow us to do this and open, of course, the bridge and invite more and another countries. So now, for example, in the awards that we gave to the best oralist participants, they have a training and mentoring with one of the most really good, important for us, Sabina Sacco. She's really good known arbitrator in the world, and she's training them like with this mentoring, like 1 year with them. Are two from Montevideo and the other one is from London. So we truly think that academic things are the beginning of everything. So the education, and when you start to prepare into the future, and of course, if you have the experience to be in the similar cases, it will be great for the students and the future of the professionals that we have from Chile to the outside in the world. So we're really happy with that.
Yeah, I will take the opportunity to very quickly agree with everything that you're saying, that institutions, it's not just about promulgating your rules and explaining how the rules work. It's about explaining arbitration. So we go around to universities all over the world explaining arbitration, even if it's through the lens of SIAC, but concepts in investment arbitration. And this may be particularly for law students, someone's first exposure to arbitration. So that's for law students. And then we also have courses for practicing lawyers through our SIAC Academy. So it might be about arbitration advocacy, not just about the interpretation of the SIAC rules. I think the idea for arbitration institutes is to develop arbitration practice, to be that thought leader, to push out new ideas, look at different ways of doing things. And then because there's such specialized knowledge in the institution, I mean, to be able to share that with practitioners and students. One thing that institutions have is data. We have a history of thousands and thousands of cases, and we are able to draw trends and perhaps share those with, as an arbitration counsel, you might be working on 4 or 5 cases at a time. We're working at institutions on thousands of cases at a time. So I think it's good to be able to try to share some of that information with the arbitration community.
Yeah, this collaboration for us is really important, Kevin. Among all of the things that we talk right now, because we know we can learn between each other about the whole things that we've been doing these years. And of course, of you that have the second place, I think, of one of the 6 most preference seats of arbitration is really good for us, because we can learn about the whole path that you have in arbitration, international arbitration. That, of course, is one of our main goals, to get better in what we do. So I don't know, Claudio, Macarena, if somebody wanna have some words to finish this, Claudio?
Yes, I just want to thank you all very much for joining this event. We especially thank Mr. Kevin Nash and Mrs. Lik Sok Hui, the CEO of the Singapore International Arbitration Center. We trust that this conference will be the beginning of a very fruitful collaboration.
Thank you so much. Yeah, on behalf of everyone at SIAC, Sok Hui, Adriana, we're delighted to have been able to consummate this MOU, and we look forward to working with you and users in Chile and Latin America. Thank you so much.
Thank you, Kevin. Thank you, Lim.
See you soon with another activity for SIAC and Camp Santiago. Thank you very much.
Thank you.
Have a nice day.